The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to answer some frequently asked questions about estate planning. We're going to explain the purpose of estate planning. We're going to explain why estate planning is important. We're going to answer the question, do I need an estate plan? What documents are needed for an estate plan? And what is the estate planning process? So let's start with the purpose of estate planning. I like to break the goals that can be accomplished in an estate plan into general goals that apply to most people and can help most people in a standard estate plan, and then more specialized goals that have an estate plan specifically tailored towards that goal. So let's talk about the common goals first, and a lot of these we're going to go into more detail about later. So first is avoiding probate when you pass away. We're going to talk about that a lot in a minute on why estate planning is important. Another is appointing fiduciaries. These are people responsible for making decisions about your life or your assets if you become mentally incompetent, or managing your estate or your trust for the benefit of your children, either through a probate case or over the long term through a trust if you pass away. Asset distribution, making sure your assets are distributed to the people you want them to go to. Especially in the case of minor children, if they are going to be in a trust and there's going to be a long-term plan for how those assets are distributed to them, making sure that the plan makes sense to you. Appointing a guardian of minor children if you're unable to care for them either due to mental disability or death. End-of-life decision-making, so deciding whether you want your life support terminated in advance if you are in a irreversible coma, rather than letting your family members make this decision and putting that emotional burden on them. And then finally, avoiding guardianship proceedings if you become mentally incompetent. And again, that's another one like probate we'll talk about more in just a minute. There's also 4 more specialized goals that can be accomplished with an estate plan. And these don't really apply to everybody, but you pretty much know if you're in one of these situations. One is minimizing or avoiding estate tax. Another is protecting your assets from creditors or future potential creditors. Special needs planning. This is if you or a child have a disability, ensuring that you can accumulate wealth or income without jeopardizing your government benefits. And finally, long-term care and Medicaid eligibility planning. So when you get towards the time when you're anticipating long-term care, you want to make sure that you don't have to use all of your own assets to pay for it, and that some of your assets can make it to the next generation, and this is what long-term care planning is about. So let's next talk about why estate planning is important. There's several goals behind an estate plan that speak for themselves. So all those specialized goals, special needs planning, long-term care planning, we don't need to explain why that's important. There's other goals that if you are in a particular situation where you're a non-nuclear family or a mixed family between 2 prior marriages, appointing fiduciaries and distribution of assets becomes incredibly important, because you want to make sure that your children are taken care of, and that your ex isn't the person in charge of doing that necessarily, or in charge of your assets, or that they're not the beneficiary of your life insurance or your assets. So in a divorce situation, those become incredibly important. 2 reasons that need some explanation that estate planning is important are probate avoidance and avoidance of a guardianship proceeding. Let's talk about probate first. So probate is a court case that is necessary if you pass away, generally owning any real estate outside of a trust or more than $100,000 of any sort of asset outside of a trust. So there's other ways to avoid this other than a trust, but the main way that you avoid probate is transferring your assets into a trust so that your probate becomes unnecessary. You don't meet one of these 2 qualifications, any real estate or more than $100,000 outside of a trust. The reason we want to do this is because probate is basically a year-long court case in which the court oversees your executor administering your estate. Problem is that your assets are tied up in the probate court for about a year, so your loved ones don't have access to them when they need them for about a year. Another problem is that probate can be costly in attorney's fees. It's a year-long court case, so you're paying an attorney, and some attorneys charge 5 to 10% of the value of the estate. So that's almost like a tax on the estate. Third reason we want to avoid probate is because it can be a major headache and a stressor for everyone involved in a time that's already stressful. But if you have a proper estate plan, a probate case isn't necessary, and rather than paying an attorney and waiting a year, your trustee of your trust can simply distribute assets immediately without having to hire an attorney and without all of the stress on everybody involved. So that's the low-hanging fruit that, regardless of whether you have a lot of money or not, you always really want to make sure that probate is avoided, and we can really help with that with a good estate plan, and that's really easy to do and inexpensive to do. Guardianship avoidance is another big important part of an estate plan. So if you have a financial and health care power of attorney while you're mentally competent, if you execute those, you can appoint somebody in the event that you become mentally incompetent due to accident, old age, or disease, to manage your financial decisions and your personal and health care decisions. And if you have those both in place before you become mentally incompetent, then a guardianship proceeding isn't necessary to appoint a guardian to manage those decisions for you. We want to avoid a guardianship proceeding for the same reason that we want to avoid a probate proceeding, because it's costly, it's stressful on the family, and it can take a couple months before someone's able to start making decisions on your behalf. Another reason that a guardianship proceeding is something we want to avoid if we can is that even after the initial case, when a guardian will be appointed, the guardian is going to have to go back into court every year and hire an attorney to help him or her prepare a report of income and expenses and assets and liabilities for your estate that they're managing every year. And if you're going the power of attorney route, they don't necessarily have to do this. So estate planning is important for a lot of reasons, but the things that we can do to help almost everybody are making sure that they have powers of attorney in place to avoid a guardianship proceeding, and that they have a trust in place to make sure that probate won't be necessary when they pass away, and that everyone can get access to their assets when they need it without having a big chunk shaved off the top for a probate attorney. So let's talk about whether you in particular might need an estate plan. There's about 4 common triggers that often cause people to come to us for an estate plan. This is just often the time of life when someone suggests it to them or they're thinking about it. But usually people come to us when they're buying their first home or when they're getting married. They're thinking about, all right, we're starting a family, we need to start worrying about protecting our assets and protecting our estate. When they have their first child, if they haven't already done so, they'll typically get an estate plan. If they put it off past that, then usually it's after they've dealt with a probate estate for their own parents, and they don't want to put their own kids through that. So they've gone through the headache of a probate estate, and they've learned, hey, if mom and dad had an estate plan, this would have been a lot easier, we would have gotten a lot more of an inheritance. So that's the next stage when they do it. And finally, in their golden years, when they realize that it's not going to be, they're not going to have 60 more years to deal with this. Sooner or later, they're going to have to do this. Those are the 4 stages where we usually see people come to us. But an estate plan can be beneficial even if you're not in the middle of one of those life events. It's easier to say who won't necessarily benefit from a will or trust. There's a couple situations where people will come to us and I'll tell them, you don't really need a will or a trust right now. You may need it down the road, but not right now. So you might not need a will or trust if your children are already grown and you want them to receive all of your assets, and you don't own any real estate, including your home, and you have less than $100,000 in assets. So in that situation where you've got a very low asset amount, you don't even own your condo, and the only people you want to inherit are adult children, then a will or trust may not accomplish a whole lot for you. But you can still benefit from powers of attorney, which are very inexpensive and will still prevent a guardianship proceeding from being necessary if you become mentally incompetent. So even in that limited situation, there's usually something that you can benefit from an estate plan. So it's important to work with somebody who's going to tailor the estate plan to your needs and not just give you a cookie cutter estate plan, because not everybody needs everything. We'll talk about the different documents in just a moment, but it's not always the case that you need all of the documents, and it's going to be less expensive if you don't use all of them. Let's talk about what documents are needed. Let's make that transition now. So basically we've talked about our various goals. Now I'll just kind of go over what documents achieve those various goals. A trust is what we use typically, again, if you are going to be in danger of having a probate estate. If you don't have any real estate, including your home, or more than $100,000 in non-real estate assets, or if you think you might before you pass away, a trust is the document that will keep you out of probate and allow you to plan for how those assets are going to be distributed either at the point of your death or over the course of the next 21 or 30 years as your children reach adulthood, or as long as you'd like, really. and it allows you to appoint a trustee to manage all of that. A will is useful if you're in a lot of various situations, but a will appoint a guardian for your minor children. So often if you have a trust and a will, it's because you have minor children and you want to avoid probate and appoint a guardian. It can also make sure that if a probate estate is necessary, that the terms of your trust will apply to that probate estate. Finally, we'll use a will if we think there's a reason for the will, but probate isn't a concern. If you've got low assets and you don't plan to have assets in the future, a will might be appropriate just to accomplish your distribution needs and appoint a guardianship for minor children. Powers of attorney are what we use to prevent guardianship proceedings if you become mentally incompetent. And a living will is what we use to allow you to make end-of-life decisions about what to do if you're in an irreversible coma. So those are the basic documents in an estate plan. It's not overly complex, and a lot of people don't need all of them. For some people, we'll do a trust and powers of attorney and not worry about the other documents. For some people, just do powers of attorney. But usually, there's some benefit to be had from all of those documents. Finally, let's talk about what the process of estate planning is. Typically, we will meet with our clients, have an initial consultation, find out what their situation is, find out what their needs are and what their goals are, and then we'll propose, here's the documents that we think you can use, and usually right there and then we'll have them fill out a brief questionnaire. You can leave them below this post in the comments section at learn-about-law.com or below this video on our YouTube station. If you found this helpful and would like to be informed of our daily article and video topics, please subscribe to us on YouTube, iTunes, and SoundCloud. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.